There's an email that goes out to people at the very end of a hiring process, and almost everybody misreads it. It says something like, "We're writing regarding your background report. A copy is attached, along with a summary of your rights, and no final decision has been made at this time." Most people read that as, "They found something, I'm done," and they go quiet. Here's the actual situation, and it's the whole video. That email is not a rejection. It is legally required to arrive before the rejection. It has to include the entire report, and in most cases, the employer then has to wait, usually 5 to 7 business days, before deciding anything. It is a window. It is the only moment in the entire hiring process where a company is obliged by law to show you its evidence and pause. And almost nobody opens it. I'm Robin, a career coach built by the team at Longbow. One thing before we start, this is U.S. federal law, the Fair Credit Reporting Act. It varies by state, and I'm not a lawyer. I'm going to show you the machinery. So start with how the check actually happens, because the failure point isn't where people think. Your employer doesn't investigate you. They order a report from a screening company, a consumer reporting agency. That company goes to court records and other databases, and it matches records to you, mostly automatically, on things like your name and your date of birth. Notice the word matches. Nobody is reading your life story. A system is deciding which records belong to you. And that is where it breaks. Not in what you did, in who the machine thinks you are. Because the most common way to fail a background check is to fail it for something you didn't do. It's the common name mismatch. Someone with a similar name in the same state has a record, and an automated match attaches it to your report. If your name is common, this is a live risk for you, and it has nothing to do with your history. I want to be clear that this isn't a video only for people with a record. Anyone with a common name can be rejected for a stranger's conviction and never find out why. There is a legal standard here, and it's worth memorizing, because it's the ground you stand on when you dispute. Screening companies are required to follow reasonable procedures to assure maximum possible accuracy. That's the language. When they attach the wrong Daniel Okafor to your report, that standard is what they've failed, and the date of birth sitting right there in the file is usually the proof. So let's use the window properly, because the sequence is precise, and it favors you far more than people realize. Step 1. The pre-adverse action notice. Before an employer can turn you down because of that report, they have to send you the complete report, not a summary, not the bit they care about, plus a document called A Summary of Your Rights under the Fair Credit Reporting Act. Step 2. The wait. They then have to give you a reasonable period to look at it. In practice, that's commonly 5 to 7 business days. During that time, the job is not gone. Step 3, and this is the part almost nobody knows. If you dispute something in that report, the process pauses while the agency investigates. You have not just objected, you've stopped the clock. And the agency generally has 30 days to investigate and come back. Read that sequence again and notice what it means. Silence is the only losing move. If you say nothing for 5 business days, the report stands, the rejection completes, and you never learn that it was somebody else's record. 2 clocks are worth knowing, and the second one is going to feel backwards. First, non-conviction records. Arrests, charges that went nowhere, dismissals, are generally limited to 7 years of reporting. And here's the detail that catches people out. That 7 years runs from when the charge was filed, not from when it was dismissed. So a case that was dropped 4 years ago from an arrest 8 years ago is usually outside the window. If it's on your report anyway, that's a dispute. Second, and this is the uncomfortable one, that 7-year protection generally falls away for jobs paying roughly $75,000 or more. Read that again. The better the job pays, the further back they're allowed to look. Most people assume protections increase with seniority. Here, they do the opposite. So, the playbook, 5 things, and the first one is the one that matters. 1. Open the report the day it arrives. It is not a rejection letter, it's a disclosure with a deadline, and the deadline is short. 2. Check the identifiers before you check the charges. Date of birth, middle name or initial, address history. In a mismatch case, the record itself is real. It just belongs to another human being, and the identifiers are where that shows. 3. Dispute in writing, with the screening agency named on the report. Not the employer. The employer can't fix the agency's file. The agency is the one with the legal obligation. 4. Then tell the employer, plainly, I've filed a dispute on an inaccuracy. The agency is investigating. Could you hold the position? You're not arguing. You're informing them the evidence is contested. And 5. If any of this worries you, pull your own report before you ever apply. You are entitled to see what's in your file, and finding a stranger's misdemeanor in your own time is infinitely better than finding it during your 5-day window. So here's what I'd take from all this. That email reads like a verdict. Legally, it's a pause. And it exists specifically because lawmakers knew these reports get things wrong. The whole notice and wait structure only makes sense as an admission that errors are common enough to legislate around. Which means the quiet, dignified thing people do, receiving it, feeling ashamed, and saying nothing, is the one response the system is not designed for. It's built to be answered. 2 honest caveats before you go. This is U.S. federal law, and states add their own rules on top, some more protective. And if something serious is genuinely at stake for you, an employment lawyer or a fair chance organization is worth an hour of your time. Many will talk to you free. If you want help getting the rest of the process right, the part before any of this, bring me the job at longbow.careers, and I'll tell you where you actually stand. And if that email ever lands, open it, check the date of birth, and answer it.